All right, it looks like we are now live streaming on YouTube. Again, welcome to the First District Court of Appeals. We have 5 cases on our docket this morning. 3 are going to be argued. And the first case to be argued this morning is Lamar Advantage versus City of Cincinnati. It's case number C20-0157. Mr. Haynes is here on behalf of the City of Cincinnati. Mr. Taft and Mr. Galasso are here on behalf of the appellees. Mr. Haynes, you will have 15 minutes this morning to argue. Would you like to reserve any of that time in rebuttal?
Yes, Your Honor. I'd like to reserve at least 3 minutes in rebuttal.
All right. And then before we begin, Mr. Taft, Mr. Galasso, have you two decided how you would like to allocate your 15 minutes?
Yes, Your Honor. Mr. Galasso has agreed for me to take the first 10 minutes, and then he will take the remaining 5.
All right. And I will keep time for everybody this morning and try and let you know when you have about a minute left, although I will err on not interrupting you if you're getting towards the end of your argument or your statement. So, Mr. Haynes, whenever you're ready, you may begin.
Thank you, Your Honor. Good morning, and may it please the court. The city is seeking a determination that it is immune from the billboard company's attorney's fee claims pursuant to RC 232351. Now, the city is not seeking carte blanche approval to engage in frivolous conduct or to prevent courts from correcting that behavior in their courtrooms. The city is instead asking the court to protect it and, by extension, its taxpayers from zealous litigants who will take advantage of any chance to engage in fee shifting. Specifically, the narrow question for the court is whether RC Chapter 2744 immunizes the city from the specific provisions of RC 232351. The court reviews this question de novo. There are 3 reasons why the court should find the city is immune. First, the claims raised in this case fall within the purview of RC Chapter 2744 immunity. Second, the cases the billboard companies cite to the contrary are distinguishable. And finally, giving effect to RC Chapter 2744 will not limit courts' ability to govern their courtrooms. In this case, the city is immune as a governmental entity under RC 274402A, which provides that a city is not liable in damages in a civil action for injury, death, or loss to persons or property that's allegedly caused by the actions of that municipality when it's engaged in a governmental function. And here, the billboard company's own words confirm that provision is implicated. The billboard company's requests for attorney's fees were pled as claims in their amended complaints, and they've consistently characterized their claims throughout the proceedings in this case, including in their briefs to the court. They've consistently claimed that the city's actions have damaged them, and they've consistently claimed that due to the injuries caused by those damages, that they should be compensated for them. If this is not a recognized tort, the allegations certainly sound in tort, or at least the it sounds like they're seeking recovery for a civil wrong. Also, the city's alleged frivolous actions relate to its performance of governmental functions, primarily its permitting and code enforcement functions, and related legal functions and other functions that are mandated by the law. Now, there's no exceptions to this immunity that apply. In the statute, these claims do not fall within the classes of claims that are spelled out in RC 274409. The billboard companies have not pled bad faith or cited any of the bad faith exceptions in RC 274403. And it's also important to point out that in RC 232351D, there is a provision that causes other provisions of the revised code to remain operable if they would prevent an award of attorney's fees under that provision. And that would include RC Chapter 2744. Now, admittedly, this is an issue that is largely of first impression. The city's provided you with the scant case law that exists on this matter, one a federal case and the other a state case. The federal case, which came out of the Northern District of Ohio, the scrapyard case, involved a matter in which the city of Cleveland pursued zoning code enforcement. And the property owner that was sued by the city claimed that the city's actions were frivolous, and it sought an award under RC 2351 for damages it allegedly incurred as a result of those actions. In that case, the district court confirmed that RC Chapter 2744 immunity applied, and that the city should not be liable for those for the request for 2351 attorney's fees. The Ohio case comes out of the second district. This is the Village of New Lebanon v. Cron case, but that case had a very different procedural posture than what's before this court. In that case, again, the Village of New Lebanon had filed suit against a property owner, and the property owner claimed that the village had done so frivolously, and that the village should be liable for attorney's fees under 2351. In that case, the second district held that the immunity cited by the village did not apply because the immunity was cited in a case that was not brought against the governmental entity. And that's important because in 274403, by its own terms, it only applies, those defenses in 274403 only apply in a civil action that's brought against a political subdivision. That wasn't the case in New Lebanon, but that is the case here. The city has been defending itself. This is a case brought against a political subdivision, but also we haven't even reached the 274403 defenses because the city should be immune under 274402A. I'll also point to this.
Would your position be any different if this were not pled as a standalone claim and rather brought as a motion?
Your Honor, I think it may depend upon the circumstances. It may depend upon how the claims are characterized. I think that's more important than perhaps the procedural step that is being taken. And, for instance, if we look at the fee cases that have been cited by the billboard companies, they all deal with attorney's fees claims that are arising in very different contexts. For instance, in the digital and analog case, the Supreme Court of Ohio reviewed whether attorney's fees awarded as punitive damages or as a punitive measure are damages. And in the Christie case, the court reviewed whether attorney's fees issued as part of an incidental award under statutory authority were damages. In both cases, the Supreme Court of Ohio held that they were not damages, but they were rather court costs. In this case, it's very different, and conceivably in a motion, depending upon what the circumstances are, could be very different. But in this case, we have an alleged wrong committed by the city that allegedly caused damage for which the party should be compensated. And that
isn't there case law that would suggest it is not a standalone cause of action, but rather must be brought by motion?
Well, Your Honor, there's a case out of this court that very recently.
That's the one I was thinking of.
The Vogel v. Albee case that would hold that it must be brought through motion, not through a counterclaim. But again, I think it's important not to elevate the form over the substance of the claim because it's really what is being sought and whether the government is immune from that particular type of claim. I'll also point out that this court in the Harrison cases recognized that immunity, that municipalities are immune from attorney's fee awards, subject to certain exceptions, including when there's a claim of bad faith, which isn't the case here, or when there's other statutory authority. Now, the court didn't really say what it meant by when there's other statutory authority, and I no doubt the billboard companies will assert, well, this is statutory authority for awarding attorney's fees against municipality. But it's important that one, again, 2351D preserves the application of other revised code provisions so the city retains its immunity defenses. And also the Kramer case, which the city provided you in its reply brief out of the Supreme Court of Ohio, made it clear that for a statute to create a cause of action against a municipality, it has to expressly or explicitly do so. And that case provides a great contrast between when a statute does and does not do that. It involved a claim against county-operated nursing homes and the employees of those nursing homes. And in that case, the Supreme Court said that the statute in question specifically held that county nursing homes were among the entities that could be sued, but it only otherwise spoke to persons being liable, like as is the case here. Only persons are liable, and because it just generally referred to persons and didn't specifically call out government employees, the government employees in that case were not subject to the provisions of that statute and continued to enjoy immunity. I'll also point out that the billboard companies have cited other cases where courts, including this court, have affirmed 2351 awards against municipalities or governments, including this court's Thomas case. But I don't think that those cases do very much to inform this situation, because they didn't address at all the interplay of RC Chapter 2744, and it didn't appear that that was raised as a defense. I think you'll also hear the billboard companies make much to do over the fact that RC Chapter 2744 is entitled the Political Subdivision Tort Liability Chapter. But I'll also point to the court to the fact that the word tort doesn't actually appear anywhere in the statute. And as this court well knows, in applying statutes, you look to the words of the statute, not their titles.
And you have about 1 minute left, Mr. Haynes.
Thank you, Your Honor. So finally, I want to point out that a decision in the city's favor will not harm courts' ability to police their courtrooms. It carries out the statute's intent to protect taxpayer resources. Courts still have their inherent power to sanction parties. You have ORC, or Ohio Civil Rule 11, that governs the bar, and presumably courts could still, on their own motion under 2351, potentially, in certain circumstances, award attorney's fees. And I think this both balances the need to continue to allow cities to have their ability to assert immunity defenses and still allow courts to police their courtrooms. And finally, I'll point out here that if the court itself, in this case, thought that the city had acted frivolously, it certainly could have sanctioned the city, called it out, warned it, and none of that happened here. So for these reasons, the city would ask that the court confirm that it is immune from the billboard company's RC 2351 claims, and that it remand this matter for further action consistent with that determination. Thank you, Your Honor.
Thank you, Mr. Haynes. Mr. Taft, I will try and keep track of your 10 minutes. Whenever you're ready, you may begin.
Thank you, and good morning, Your Honors. Answering your question, Judge Myers, about whether this should be brought by motion, the case law in Ohio is clear that it can be brought by motion or by a separate claim. This was all briefed down in the trial court. It wasn't an issue in your court, and so you're not going to find much in the briefs, other than there's a statement in the city's brief at the bottom of page 8, where it says these claims are indistinguishable from other civil claims requesting monetary compensation for damages caused by allegedly wrongful actions, and it makes no difference whether they are raised within a pleading or by motion. And I know there was that footnote in the Sixth Circuit case, the scrapyard cases, but that footnote that it should be brought only by motion is simply does not reflect Ohio law on the subject today. Keep in mind also that this was a 12B6 motion to dismiss. So when the court considers a motion to dismiss, as the trial court did below, it assumes the facts as alleged are true, and the trial court specifically held that we had properly pled this claim for frivolous litigation conduct, that we had properly pled it under the Ohio rules. And that in itself distinguishes the scrapyard cases, because the claims for attorney's fees in those cases were dismissed by the district court because they did not comply with the federal particularity rules. And so they were dismissed for that reason only, not on 23-2351. The fact is that there is absolutely nothing that supports this claim for immunity. The city claims its immunity in 274402, which is labeled as a tort immunity statute. And we're not relying on that title, we're relying on the language of it. It says they have immunity for damages. First keyword, for injury, death, or loss to person or property. The courts in Ohio have repeatedly held that a claim for attorney's fees is not a claim for damages. It's in the form of a claim for costs, and attorney's fees is a part of the cost. Hence, it's an equitable type remedy, and it does not come within the damages. So it does not come within that part of it. Plus, it's not a tort. It's not a claim for injury to personal property, for injury or death or loss to person or property. This is a separate claim for frivolous litigation conduct. So there is nothing that the city has cited you to in 2744. There is nothing we have ever been able to find in it. And we can't find a case anywhere that says this would be applicable to claims for frivolous litigation conduct. So then we go to 23-2351. That's a statute that the claim is under. And there is nothing in that statute that exempts the government here. There is an exemption in inmate cases, but nowhere else. And if you look at B4 of that statute, it simply refers to the claim can be made against a party or the party's attorney. There's no exception for the government. It's a party, and the government here is a party. So there is no place in 23-2351 that grants this claimed immunity or even hints at it. So then we go to the cases, and the cases clearly say that, number one, the claim for attorney's fees under 23-2351 are not damages claims. Claims for attorney's fees generally are not damages claims. They can be, but not in this context. And the city tries to confuse our other claims that are still sitting down in the trial court. Our federal claims, 1983, 1988 claims for damages and for attorney's fees, but that is totally separate from this claim for frivolous litigation conduct under 23-2351. And those should not be confused here, and they're not before the court. And it's misleading. The cases that have looked at this issue, you look at the Brown case. The Brown case says that the tort immunity claim is for torts, and that was a replevin case. And the court said, this court, the first district, said that that statute does not give immunity in replevin cases, and other cases have held doesn't apply in declaratory judgment, injunction cases, other cases that are not tort injury, damages for injury to persons or property cases, it does not apply to. So the cases, there is no case that I have read or seen that supports the city's claim here of immunity over this appeal. The city was before this court, 15 years ago on a 23-2351 frivolous litigation conduct case. And that case is very similar to this. This is the Thomas case. In that case, the city withheld a contract, and the city took positions that were contrary to what that contract provided. And they took positions in the trial court that were contrary, and they won. Appealed up to the Court of Appeals, they took the same contrary positions, but the contract came out, and then it came out there that they were taking positions that were not supported by the law, that were contrary to the documents they were withholding. And this court reversed the finding against the plaintiff in that case, which is a firefighter, sent it back to the trial court. The trial judge saw all of this, reversed his decision held in favor of the firefighter and held the city liable for frivolous litigation conduct. Very similar to what is alleged here with particularity in our claim. And it came back up to you, back up to the first district, I'm sorry. and the first district held that indeed the city was liable for frivolous litigation misconduct under 23-2351. You can't get a whole lot closer. So what the city has done here is that the city has raised an immunity that just doesn't exist anywhere, and an immunity that the courts have repeatedly said is for a specific purpose and not for anything outside of that. So then the city says, okay, well, policy, and this is a big argument in their brief, policy should cause this court to grant them immunity. What policy would there be to grant the city immunity to engage in frivolous misconduct in the courts? I know of no case that grants them that. I know of no statute that grants them that, and it certainly would be against policy. But where the language of the statutes are plain and clear, the immunity statute language is very plain and clear, and the courts in Ohio have repeatedly interpreted it so. 23-2351 is plain and clear, no exemption for the government here. So when it's plain and clear, it's the duty of the courts to simply apply the language. And overall, and this court has repeatedly said, it is not for the court to dictate policy. That's for the legislature. And if the legislature wants to grant immunity, then maybe that would have to be dealt with at a future time. But we
Mr.
have
Taft, you have about a minute left.
Good, because I'm finished anyway. We have a case here where this motion had no place, no foundation in the statutes or in the cases. Or otherwise. And it still has no basis in this court. Even though a statute allows an immediate appeal, I would assume you would have some basis for the appeal. And there is no basis in this court either. And the city should not be given immunity from engaging in frivolous litigation in the courts against the citizens and the companies in the city. Thank you.
Thank you, Mr. Taft. Mr. Galasso, you have 5 minutes.
Thank you, Your Honor. I think before I talk about the brief, the one thing I wanted to, based on what's been argued so far before the court, one of the statements that was made was that there has not been an allegation of bad faith, and that this was brought on a claim versus a motion. Which if you look at the entry that's appealed from, what happened is the city had filed a 12B6 motion to dismiss based on immunity. And the plaintiffs had filed in response to that an opposition to the 12B6, but then they had also filed a motion for partial summary judgment and a motion for sanctions under 23-2351. So I think that whether the law would require it be brought by motion or claim, the order appealing from deals with both of it. And I note that the trial court said that under Civil Rule 8's liberal notice pleading, plaintiffs are only required to make a short and plain statement of the causes of action, not required to plead with a great deal of specificity. Taking all factual statements contained in the complaint as true, the court cannot say the defendants are entitled to judgment as a matter of law. And so if you look at that and you juxtapose that with whether there's bad faith, what the basis that we have to assume is true is that there was false testimony and manufactured evidence. And if you didn't use the express term, quote, bad faith, end quote, I think what the court is saying is that type of conduct is bad faith. So I'm not sure that that's necessarily a relevant distinction for purposes of this case, but I think that the court could be much more confined in its analysis here by simply going to right where the city points us, which is 274402A1. And it says that a political subdivision is not liable in damages in a civil action for injury, death, or loss to person or property allegedly caused by any act or omission of the political subdivision. and so it simply is that that this particular claim is not the sort of tort claim that is given immunity. And this court wrote an opinion on November 25, 2020, Brown versus Cincinnati, 162 Northeast 3rd, 1274. And this court in paragraph 11 talks about that the grant of immunity is for making a political subdivision not liable in damages, and attorney fees are clearly in the nature of costs. And so the court continues, it says, thus, immunity under Chapter 2744 is limited to damages and tort. And so the frivolous litigation statute is just not in the nature of something that's a tort, nor is it something that is remedied by damages. And I think it's properly before the court as a final appealable order on the immunity issue. And it's been brought by both a motion and a claim. And the trial court has determined that the city's not entitled to immunity. Thank you.
Mr. Galasso. Any questions from the panel?
No.
Mr. Haynes, you have 3 minutes remaining.
Thank you, Your Honor. Just a few quick points. First of all, Mr. Taft pointed to the part in the city's brief where the city had argued it didn't matter how a claim for attorney's fees arose in this context, whether through a counterclaim or through a motion. And I just wanted to point out that the city recognizes that this court has held that it should be through a motion. And at the time that the city briefed that, I think it was just an unfortunate timing that the case law, whether it had not been quite clear, was made clear by this court essentially at the same time that our brief was filed. So we recognize that the court has taken that position, and we're not going to dispute that here today. I also want to point out that words matter. And as you've heard throughout the argument on the other side today, this is still characterized as a claim against the city. It's still characterized as damages. It's been argued that way throughout. And so here we have what's arguably a claim for a civil wrong, for injuries that were caused that caused the other side to incur attorney's fees for which they want to be compensated. So that fits squarely within the words of the statute, which are what matters here, Your Honor. And finally, on the bad faith, frivolous conduct distinction, I do want to point out that those are two separate contexts, or those are two separate concepts. Bad faith is generally recognized as a common law claim, and frivolous conduct is statutorily defined in 23-2351. Bad faith has a subjective standard, and frivolous conduct has an objective standard. There's been no claim asserted or alleged by the other side of a bad faith common law claim here. So I want to be clear that that is what I was referring to. We only have the statutory frivolous conduct claim before the court. The city should be immune from that claim under RC 2744, and we ask the court to rule accordingly. Thank you.
Thank you. Any questions from the panel?
Oh, thank you.
Thank you, everyone, for your arguments this morning. We will take this case under submission and give you a timely written opinion. Ms. Hayden, if you will now let our next case into the courtroom.
Thank you.
Thank you.
Good morning, Mr. Bonner.
Good morning. How you doing?
Fine, thank you. Next case on our docket this morning is Blue Tide Partners versus Bonner. Mr. Bonner is here on his own behalf. We have been informed that the appellee is submitting on the brief. So, Mr. Bonner, if you want to argue today, you'll have 15 minutes to argue your case. If you would like, just submit it on the brief, which means that we would take everything that you've written and consider everything on the written record. You can do that as well. And I will leave it to you, sir, whether you'd like to argue or whether you would like to submit it.
I would like to argue the facts.
All right,
so
you
can
will
get a
have
better understanding.
you will have 15 minutes this morning to argue. I will keep track of your time. Whenever you want to begin, you may begin.
Thank you. My first thing to say was I was under a leasing contract, and I understand that under a leasing contract that if any raises and rent and all of that happen, it got to start after my leasing contract is up. And this comes from the state of Ohio tenants and landlord. The handbook that I had got off out of it. Well, they sent me a website to go to from the library up here, and I read that part. I was never notified of no rent increase. My lease wasn't up until October. I was paying extra money, and the extra money that I was paying per month was I had a puppy, and I didn't want the puppy to tear up the carpet, and I end up having to sign a new lease in order to get new carpet and everything. However, Greg sold it to Blue Tide. Blue Tide didn't want to honor my the pet, and they told me to get rid of the pet. I got rid of the pet, but I was already in the system of paying extra money, and my wife just kept paying the extra money every month. She just kept sending 600, 600, 600. July 10th, no, not July, January. In the month of January, I became, I was on month to month starting in the month of October. October was my first sign of me starting month to month rent. I called them inside of January. The lady admit that I called her, but then she backtracked on it. And that's all inside of the transcripts. And if you look inside the transcripts, they charged me for an extra month of rent. And I asked Mr. What's his name? Clump. Let me get it straight. I had it highlighted. You will see inside of the transcripts that's dated for the February when I turned in the keys. Where they stated he stated that he didn't know what the rent was. He said that he assumed that it was 600 because that's what I was being paying. He also inside the same transcript, he agreed for the okay. He agreed because I stated in front of the not the judge but the magistrate that I wanted to turn in the keys and do a walkthrough the next day, and he agreed to it right here inside of this transcript. He said I do not have a problem with that. And with that being said, he never answered the phone for the walkthrough. And the next time I could give him the keys was when I seen him again on the 7th, because they do not have no Dropbox. They do not got no live rent office. They don't have nothing there. And for me to leave keys inside of an apartment, even though it's empty, it's a lot of stuff that goes on over there. I didn't want nobody to come in there and take stuff or tear up stuff. And they try to charge me for everything. And I did that because of the equipment, the stove and everything that I had in there was filled up with maggots and everything. So I got tired of going back and forth with them. I went to Sears, which this right here. I bought a stove and a refrigerator. And copies of this was sent to them, and I sent them their equipment back, but it was mold growing in there, and the place was not at the best of upkeeping. And I didn't want to tour anymore for them to try to charge me. So for the extra month of rent, I feel like I don't owe because it was for 7 days, and me and Blue Tide was supposed to do a walkthrough, and I was supposed to hand them their keys back the next day, and they never answered my call and showed up. I don't believe that that's my fault that I had them keys for them 7 days. It was the fact that they didn't show up. And as far as the extra rent goes, I feel like the extra $100 that I've been paying is more than enough to cover what they saying that I owe them. Because I got over 18 months of paying extra rent. Hold on. I got 15 months of paying an extra $100. So that'll be a total of $1,500 extra that I done paid them that didn't need to be used. They didn't sue me for any damages. They don't got the paper from the walkthrough. They don't even have a copy of my contract. Greg Klein admitted that he gave me the copy of the leasing agreement inside of the court when we went to trial in front of the magistrate. I think that I presented everything. I wasn't able to bring the guy that he had me give the money to after he had his surgery. So they discredited that the letter that guy wrote. But however, I felt that the extra money that got taken, like I'm still short $300 on the deposit that I gave in. They only credited me partial of the deposit because the guy wasn't there. And they used too many words like assume and I guess and I assumed. But under a contract, you got to be for sure. You got to be able to tell somebody what you signed up for, what you agreed to, what you did tell somebody they can do and can't do. You can't say, well, I think this happened or I don't think this happened. You got to be more certain. And I proved that I was certain with the question that I asked and how they said one thing and then went back and said another thing inside of their statement. I'm just going by their statements and the rental contract. The rental agreement stated that my rent was only $500. I was paying $600. I feel that I should have some compensation there. The rent on my contract, it say if I'm late, I gotta pay a $25 late fee, but they charged me $50 late fees for each month. I don't think that was accurate because I never received nothing by mail or verbal or text. I never agreed to any pay increases, any late fees increases, or no, I never agreed to none of that. And I was never notified of any changes. And they,
Mr. Bonner, let me ask you a question because I want to make sure that that I'm accurately kind of summarizing your position. And please let me know if I'm correct or incorrect. As I understand two of your main arguments, the first one is that you shouldn't be liable for that last month of rent because you tried to turn over the property before that first week. Blue Tide didn't show up for the walkthrough, so you had no way to give them the keys back, and therefore you should not be charged for that week and in essence that last month of rent because it was their fault for not showing up for the walkthrough. Is that an accurate summary of that argument?
that's a very accurate summary of that portion right there, yes.
All right. And then the second part of your argument, or one of the other parts, is that you were paying $600 because that included $100 for the pet fee. You ultimately got rid of the pet, but your wife kept paying $600 instead of going back to the $500. And your position is that the rent was $500. That extra 100 shouldn't have been paid because that was a pet rent for a pet and not part of the base rent. Is that part of the argument?
somewhat correct. The pet fee was only $50. So it was $25. So besides the pet fee, it was an additional $75, but it went to an additional $100. The extra $75, because me and Greg Klein had an agreement that when it's time to replace the carpet, we could just replace the carpet and be like, I'm paying a portion for the carpet to get replaced, and he was paying for a portion of the carpet replaced if the dog tear it up. But if the dog don't tear it up or don't use the bathroom on it and all that stuff, I would get the money back. But however, he sold the property to Blue Tide. And Blue
Okay. Thank you. That clarified it. Thank you very much. You still have about 5 minutes left if you'd like to keep arguing any point that you haven't covered yet.
Okay, that's basically my argument, is the extra money that I paid, that I felt that I was accountable, that I should be accredited for, and the my deposit, which I had to give to Joseph, which was the land's keep for Mr. Klein, and Mr. Klein said that he denied that I gave the money to him, but Joseph wrote the letter, the memo, but it wasn't accepted because I didn't know that I had to have him there in the courtroom. And Mr. Klein admitted that he's seen my dog on the property a couple times. He tried to go back when I started, the way I questioned him, he went back and retracted some of the statements and everything, but the statements, it shows it inside the transcript, Mr. Klein was aware that I had a dog before he sold the property to Blue Tide. And that's all I have.
All right, thank you. Any other questions from the panel this morning?
None from me. Thank you.
Mr. Bonner, thank you very much for your arguments this morning. We will take this case under submission. We will give you a timely written opinion.
Okay.
Thank you.
Thank you.
And Ms. Hayden, if you will let the next group into the courtroom. Good morning. Our final case on the docket today is State versus Crump, and that's two cases consolidated, Appeal C-19, 0636 and 0637.
Yes, Your Honor.
Ms. Peters is here on behalf of appellant. Ms. Woodall is here on behalf of the state. Ms. Peters, would you like to reserve any of your 15 minutes for rebuttal this morning?
Yes, Your Honor. I'd like to reserve 5 minutes, please.
All right. Whenever you are ready, you may proceed.
May it please the court, Ms. Woodall. Most parents would be surprised to learn that if a police officer should observe a non-life-threatening, non-emergent injury to their child and request to examine that child or have an ambulance called, that the parents have no right to refuse that request or else be arrested for obstructing official business. In this case, Mr. Crump was convicted of both obstructing official business and failure to disclose. Addressing the first assignment of error involving the obstructing of official business, the statute requires that no person without privilege to do so and with purpose to prevent, obstruct, or delay the performance of a public official by any authorized act within the public official's official capacity shall do any act that hampers or impedes a public official in the performance of the public official's lawful duty. The key in this case is whether or not my client acted without the privilege to do so. When he refused to allow police officers and as personnel to examine his daughter for a potential injury. The U.S. Supreme Court, as well as the Ohio Supreme Court, have both held that a person has the right to refuse any type of medical treatment. Parents parents have the right to exercise that right on behalf of their minor children. In this case, Mr. Crump lawfully exercised that right to refuse to allow police officers or fire personnel to examine his daughter. Now, granted, this privilege that he had to refuse any type of treatment or examination is limited, but in this case, there was no evidence presented at trial which would have taken away Mr. Crump's privilege. There was no allegation raised at trial or proof that my client did anything to harm his daughter, was responsible in any way for this injury. And there was also no proof and no evidence that the injury to his daughter was life-threatening or in an emergent situation.
Now, was that apparent though at the time the police officer approached them? I mean, later, yes, but the police officer had no knowledge, did he, of whether or not the parent might have been harming the child?
Well, that is true, Your Honor, that at the time that the officer might not have known or didn't know.
We're looking at hindsight here.
In hindsight, but we're also talking, what is the conviction? The conviction here is what was proved at trial. They have to prove that my client, when he refused the medical treatment and examination, acted without the privilege. And he had the privilege. Now he had the privilege. He asserted that right. He identified himself to officers that he was this girl's father and that he did not want anyone touching his daughter. And that he was asked, will you allow fire personnel to examine her? And he said no. So the officers at that point in time knew he was asserting his privilege. Granted, they might not have known whether or not at that time that privilege could have been lost. However, they had alternate avenues. They could have sought, as we pointed out, the probate court or juvenile court could have taken authority over the child and allowed examination to occur.
Well, what if, for instance, when they approached, take a more extreme case, the child is lying there bleeding heavily and the parent is standing over there with a knife in his hand? Can he assert his parental privilege and say you can't do anything?
No, Your Honor, I would say no, not in those circumstances, because because the case law has recognized an exception to that parental authority when there is a life-threatening situation or an emergent situation involving the child. But that's not the case in here. The officers said that the hand looked swollen, or maybe there were some marks on her hand. That's not.
How do you know until the examination is done if maybe there are internal injuries, maybe there's severe bruising that's not apparent? And I guess my corollary is you've added the language "and examination." A parent has a right to refuse medical treatment. You've added "and examination." Does the case law say examination or does the case law say treatment? Because to me, those are two different things. The parent can say, my child has chicken pox. I don't want the child treated for that chicken pox. That's different than having a police officer or a medical professional examine the child to determine whether or not the child has been injured by somebody, needs emergency treatment. Does the case law have that word examination in it, or is it treatment?
I believe most of the case law uses the word treatment, but I would argue in order to have treatment, you have to know, yes, there has to be an examination involved. And so if you can deny the treatment, I would posit that you can also deny the examination, that there doesn't a right when there's a non-life-threatening situation. I mean, both officers clearly testified. Officer Cummins and Officer Van Horn both indicated, yeah, there was nothing life-threatening here. Yes, were they concerned about the child? Yes, but there are other avenues other than forcing a parent to require them to have their child examined and treated.
Well, what if the police officer suspected that whatever injuries the child had were inflicted by the father? Don't they have a right to look into that?
Certainly, Your Honor, they have the right to investigate. There's no question. But investigation is something separate from being convicted. Again, because this only
Ms.
this.
Peters, let me stop you there. Well, weren't the police conducting an investigation to determine whether this girl was injured? They called the fire department. Apparently, 10 officers showed up they were apparently investigating something down the block. Weren't the police investigating, why this girl's hand was red, swollen, and injured?
Well, for a time being, they couldn't even identify that there was a child that was injured. I mean, Officer Cummins had reported it, but then Lieutenant Van Horn couldn't initially identify any child that was injured. So I've lost track. So yes, they can investigate, but investigation doesn't necessarily include the right to force a parent to have their child examined by a medical professional without a court order.
So
go ahead, Judge.
I'm sorry. You had suggested that when the police come upon these scenes and they suspect that there may be an injury to somebody, a child, well, in this case, a child, and you said do you want them to call and wake up the probate judge and then have a hearing before anyone takes a look at the child? Is that what you're suggesting?
That you mean this occurred at 6 p.m. in the evening, so I doubt the probate judge was asleep.
Okay.
But
well, assume he's having dinner with his family, and there many things are going on within Hamilton County, and I'd expect that this is a fairly common occurrence. So you're saying that somebody needs to contact the probate judge whenever, and then the probate judge, trundles down to the courthouse and then gathers everybody together, and then there's some sort of hearing before any treatment can be rendered?
When there's a non-life threatening, non-emergent situation such as involved in this case, yes, the police need to take the appropriate action in order to secure that examination when the parent is refusing the examination.
Ms. Peters, let me follow up with on both Judge Sunderman and Judge Winkler's question, because if we take your argument to its conclusion, in a case where a child maybe was beaten and is suffering internal injuries that are not apparent when the police arrive, and the parent says, no, you can't examine my child, you would be suggesting that the police at that point could not examine the child, and then God forbid the child would succumb to her injuries an hour later. I mean, that's what you're suggesting.
No, I think if in that type of situation, there would have been, again, you have to keep in mind what was the injury in this case. Okay. Your scenario where a child is beaten like that and would succumb to injuries in an hour would suggest that there would be more visible injuries, which would indicate some type of life-threatening instance occurred.
Maybe not.
Oh.
And again, but in this case, we talk about it as being hindsight, but for the officers. So I'm not necessarily saying that they couldn't have arrested. It's the conviction part of it. Can my client have been convicted? Because it is proven, it was not proven at trial that he acted without privilege, because there was no allegation at trial that my client was responsible for this injury. So therefore, that he lacked the privilege.
Well, no, nobody's saying that he's responsible, but let's say somebody came along and beat up the child, and the parent is there, and the police officer comes and says, oh my God, let's take a look at that child. This could be serious. Can he assert his parental privilege at that time and let the child perhaps die?
well, I guess, I mean, what role the officer takes as far as arresting the parent for obstruction. Now, I granted that in this scenario, you're saying that the parent wasn't responsible for the injury, but is still
No.
refusing.
Well, whether he was or was not, that can be determined later. But the problem is helping the child, and the officer is saying we need to get medical attention for this child, and you're saying that the parent, whether he did it or not, if it seems that the child is seriously injured or injured, to some extent, the parent can stop any possible examination or treatment.
The parent has the right to assert that. Then the question becomes whether or not they're lawfully convicted of obstruction. So obviously in this case, the officers ignored the Mr. Crump's assertion of this privilege, and they arrested him for obstruction. I would posit that in these scenarios that the police officers would do the same thing. They would ignore the parent's assertion and get medical treatment for the child. The question then becomes, can the parent be prosecuted and convicted for obstruction when in my scenario, there is no life-threatening injury, no emergent situation, and no proof that my client caused the injury and would have lost that privilege.
So you have to wait until we see what happens to the child. If the child dies, he's guilty, but if the child recovers, maybe he's not guilty. Is that what you're saying?
No, because again, you're taking it as confusing it with the life-threatening situation versus the non-life-threatening.
Well, sometimes it isn't apparent whether there's a life-threatening situation. It could be an internal injury.
But that's not the facts in this case. In this case,
but you're saying here's what the law should be, and I'm saying the officers come up, they don't know. All they know is they see an injury and they think it should be looked at.
And that is part of their community caretaking situation. And it doesn't even necessarily mean that they have to suspect, yes, my client, but my client has his own rights. And now, I'm not saying that my client asserted any type of religious belief, but some parents have their own religious belief about not wanting any blood transfusions. And in that case, you have to get a court to intervene in that situation. And so there's no reason why they couldn't have tried to get a court to intervene in this situation or have child welfare check on the child if she was taken home and without being examined by the paramedics or the police officers. There's nothing to say that asserting this privilege stops law enforcement from continuing to investigate and determine whether or not this parent was responsible for the injury to the child, or whether or not the child is in a life-threatening situation.
And Ms. Peters, I've let you go way over your time because
Okay.
it was due to our questioning, so it will not count into your 5 minutes. But unless the panel has other questions at this time, you will still have 5 minutes left in rebuttal.
Your Honor, could I take just 2 more minutes then to address the second assignment of error?
Yes, and that will leave you with 3 minutes then. Yes.
Okay, so the second assignment of error involves the offense of failure to disclose. Now that offense, in order to be convicted, requires that the person refuse to disclose either their name, address, or birth date. Now, what's vitally important here is that you review exhibits A and B, which is the body worn cam video that was taken from Officer Perry and Lieutenant Van Horn. The relevant portions on the Van Horn's body cam video is at 9:30 to 9:13, or I'm sorry, 9:30 to 19:30, and for Officer Perry, 8:35 to 19. during that time period is the time period where they're actually engaging my client in any type of discussion. And then during that time, at no time do you ever hear any officer ask my client, what is his address? I know Officer Perry testified at trial, he did ask this question, but you'll actually see from Officer Perry's body cam video, he does not engage my client in any type of conversation until after my client is arrested. So therefore, this conviction for failure to disclose is totally unsupported by the evidence and against the manifest weight. So we would request that you reverse that conviction as well as the obstruction. Thank you.
All right, thank you. And you will have 3 minutes left in rebuttal.
Thank you.
Ms. Woodall, you may begin.
Thank you, Your Honors, and may it please the court. Megan Woodall on behalf of the city of Cincinnati. Judge Myers, I think what you pointed out is really the key distinction between the defendant denying medical treatment and the defendant denying an investigation or an examination. So we have an off-duty officer who comes on scene. She sees that the child has an injury, that it's swollen, her thumb, there are white marks, she's crying, she's wearing the sign that says, I am a thief. And when she tries to talk to the young girl, her aunt comes over. So she goes into District 5 to get additional uniformed officers to investigate what is going on. And that's really the crux here. It's, can a parent assert whatever privilege we're talking about in the context of an ongoing criminal investigation? And I would submit no. And for that reason, Mr. Crump's conviction for obstructing official business was not against the manifest weight of the evidence and was sufficient based on the evidence that was presented. If an officer were investigating a child sex abuse case, or, you know, Judge Sunderman mentioned a stabbing or a child being beaten, adopting, you know, the appellant's proposition that they want the court to establish in this case would mean that as soon as a parent would say, no, you can't look at them, you can't ask them questions, you can't examine any injuries, that's the case. The officers can't investigate anymore. This isn't a situation where we're at a hospital, a child has cancer, and a parent says, I don't want to treat based on my religious beliefs. This is a case where we have visible injuries from a child. We have officers who on page 54 of the transcript indicate that they believe there might have been a potential domestic violence or assault, and the defendant was a suspect. Now, were charges ever brought? No. But at the time, was there an ongoing investigation? Yes. Did the defendant know that? Yeah, they'd said, the child's told us that she's injured. Can we check her out? We need fire to check her out. Was there an affirmative act? Absolutely. He grabbed the child. He put her in between himself and the officers. He said multiple times that fire couldn't treat her. Their actions were hampered by his conduct. We had a 30-minute delay in which this child, who potentially could have had a broken bone, we don't know, wasn't able to be examined. And for those reasons, his conviction was proper. And as to the failure to disclose, if there are no questions on the first assignment of error, as to the failure to disclose, officers had reasonable suspicion to believe that he was committing OOB. So even if this court finds that his conviction was against the manifest weight of the evidence, there still is that reasonable suspicion, and he failed to disclose his address as testified and as believed by the judge who saw the video and heard the officers testify. So if there are no further questions.
Let me probe you a little bit on that latter. Ms. Peters has said that the officer that testified that he failed to give the address, that came only after he was already arrested. Is the testimony that he asked that question before her client was arrested?
I believe if you look at the context of the transcripts and when they're talking about it, it seems to be where Officer Perry asks him for his name. And you can hear on the body cam him tell Lieutenant Van Horn, my name is Mr. Crump. And Lieutenant Van Horn says, well, what's your first name? And he says, Sean Crump. He tells Officer Perry his name's Sean Crump as well. So you can hear that. And then based on the transcript, and I don't have the exact page in front of me, but it does appear that it's within that same context. And also, I mean, if you look at failure to disclose, it's no person who's in a public place shall refuse to disclose his name, address, or date of birth when requested by a law enforcement officer who reasonably suspects either of the following: the person is committing, has committed, or is about to commit a criminal offense. So it wouldn't necessarily matter if he said it on the street or in the cruiser. He's still, you know, in a public place refusing to disclose that information. So if there are no further questions,
Any other questions from the panel?
No.
I rest on the merits of my brief on all issues and ask this court to affirm.
All right, thank you. Ms. Peters, you have 3 minutes remaining.
Thank you. I would just like to clarify the one point on the failure to disclose. I was not saying that my client, what I'm trying to say is my client was never asked by Officer Perry or any other law enforcement officer for his address. I reviewed the videos just yesterday, and that's why I'm urging you to look at the videos. The specific conversation that starts with about what is your name, and my client responds, starts at minute 13:14 of Officer Van Horn's body cam video, and at approximately 12:18 of Officer Perry's. Now that goes through, there's then there's a bike officer who addresses my client, and that's Officer Ball. But he also doesn't ask my client what his address is. So I urge you to look at the video, and you will find that there is no mention during the video portion, especially Officer Perry's video, where he asked my client for his address. He doesn't even start addressing my client until after he's arrested. And you'll see what he asked him in the patrol car. He asked him for his telephone number. He asked him for emergency contact. He asked him if he was married. Those questions were all asked. The one question that wasn't asked, and that was the reason why the trial court convicted him, is what is your address? And he was never asked that question, so he did not fail to disclose that. And as far as the allegation that the 30-minute delay, there was a 30-minute delay in the treatment, again, look at the videos, you will see that's not accurate either. And the question here is not the legitimacy of the arrest. The question here is the legitimacy of the conviction. The conviction, so the privilege has been sort of indicated to be an affirmative defense. Mr. Crump has asserted that affirmative defense. Now, what was the evidence at trial to overcome that privilege that he had? And there, I would submit there is none. Nothing to indicate that he would have lost his privilege to refuse to allow treatment to his daughter. If there's no further questions, we would request this court to reverse Mr. Crump's convictions. Thank you.
Any other questions from the panel?
No, thank you.
Thank you both very much for your arguments this morning. We will take this case under submission. We will give you a timely written opinion. And that will conclude our arguments this morning for the First District Court of Appeals.